koti hizi si jana juzi shila kapewa 70,000 amekuja kasa na naona ya mahindi daktari mahindi wataki sio ifanye
niliona
they dump you somewhere. Yes, somewhere so you don't know which way is. Yes. Number one.
Aranya, can we help you?
Aranya.
Umwenga, Miss Umwenga, Mr. Joshua, Mr. Mwaniki, and Mr. Owor for the first petitioner, for the first petitioner and first and second petitioners.
Miss Mwangi, I'm here for the first.
September 2024. The first respondent is in court.
Yes, my lord. First, father's son, yesterday. Is on record. My lord, I'm with Mr. Ochindo in court. We will brief the court on the circumstances and this current update. And also the court and as audience because
my lord, but we do not know who he is. He has not been introduced. His quorum was stated and he was not mentioned, my lord. We do not. We are objecting to that.
Mr. Okindi
is the Director Legal Services of the National Police Service Commission.
Kindly please, Your Lordship, I'm very sorry I'm late. Matter for the second respondent. Just for the record.
we issued orders on the 3rd directing the first respondent to appear before you. As of that day, you had previously issued 3 orders summoning the Inspector General of Police to come to court. It was our expectation that those orders would have been complied today, as you directed in your ruling. Unfortunately, my lord, the court is being treated to the same scenario that was treated on the 3rd and on 26th. My lord, we have appeared, this is the 5th time. Judicial time has been wasted because of one individual who is deliberate in ignoring substantive court orders. As you directed in your ruling, my lord.
If I can object, my lord, I've not said, you've not gotten to.
It is important that you go back to that so that you don't keep on
Thank you, my lord.
Then, my lord, then I should go first.
Okay, just a minute.
If you are
If
going
you
to
look at
tell
my
the
ruling, if you already have a copy of my ruling at paragraph 20, from paragraph 20, this is what I see. And this is what I expected you to do. That actually not even paragraph 20, I will go straight to paragraph 26 of my ruling. It says, I will thus order that the Inspector General of Police shall physically attend court on Thursday, 5th September 2024 at 10 a.m. to find the content before further proceedings in this matter. Yes. That is,
Then, my lord,
that is the last paragraph of my ruling. It summarizes all what we have seen because we looked at exactly what had been happening from the time this matter came to court on the 23rd of August 2024. And now we are on the 5th of September. So we are trying to deal with one particular issue.
yes, my lord,
And of
then-
course, the reason for non-attendance, for the reason for asking the Inspector General to come to court is as a result of what had happened earlier. One, since this petition was filed, there had been no response from your end. There had been no appearance from your end. All that had happened earlier. And now, it reached a point now when we have to summon the Inspector General of Police to come and tell us why there has been apparent disregard, actually not apparent, disregard of all these orders of issue. Yet there are people in court who are claiming that the petitioners were arrested and they have never, even despite them reporting to the police and filing this petition, nothing has ever come out of it. They have not been told the whereabouts of these people. It is not clear where they are held. It is not clear why the orders of the court are not being obeyed. All that. That is where we have reached.
yes, my lord, then
Yes.
I can address you.
Just a
right?
minute.
Yes.
So I will want to give Mr. I'll have to give Mr. Manua a chance to finish what he wants to say. Then you still have an opportunity to explain yourself. If the content must be purged or punished for us to proceed. Otherwise, we are now stuck here. We cannot move. Either we punish the content or the content is purged. We are not doing about it.
My lord, we are well guided.
You issued on that day and previous dates, they had a classic chance today to come before you with the first respondent to give context to what is contained in the petition. My lord, their failure to present the first respondent then invites the court to sentence, to declare that the first respondent is in contempt. My lord, it's needless to say that these courts have determined that the nature of contempt proceedings are criminal. And my lord, I want to cite the case of Sam Nyamwea and 3 others versus Kenya Premier Limited, 2015. My lord, the court said Sam Nyamwea and 3 others, my lord, versus the Kenya Premier Limited and 2 others, 2015, EKLR. And my lord, in that case, the court was firm and indicated that contempt proceedings are criminal in nature. Because they involve loss of liberty. And my lord, that case is a classic case to the situation we find ourselves here today. the Inspector General of Police was supposed to come and explain the whereabouts of the first, of the second, third, and fourth petitioners. It is a question of liberty. The rights of arrested persons. My Lord, it's almost 3 weeks since the individuals were arrested and disappeared. He had a duty to come and explain. His failure amounts to a criminal offense. And my Lord, we seek that this court asserts its position and finds the first respondent in contempt, not only for one order, but 4 orders of this court. I'll invite my learned colleague, Mr. Owor, to make the presentations.
Two occasions. In the morning of that day, 23rd of the 3rd, and the afternoon of the same day, this court invited the Inspector General of Police to shed light to the disappearance of 3 persons who are citizens of this country. In its ruling, the court reasoned that summon is based on 2 fundamental reasons. One, the IG has specific constitutional duties under the Constitution to preserve or to promote the security of persons in this country. So whether they have admitted that there's an arrest or not, the orders of this court must have force of the law because they derive from specific provisions of the Constitution that bestow on the IG and other security agencies the obligation to preserve security of persons in this country. Secondly, my Lord, we have placed before you evidence that these persons were abducted in relation to the protests that have been going on. And those abductions and arrests are done by agents and officers who are under the authority of the IG or the respondents who are cited in this matter. That is the second reason to which this court based its ruling, to have the IG explain himself and purge the contempt. We can't appear today and be told that we have officers of the court. We are either sitting today to comply with court orders, or this court has no power to make orders. Precisely because they are officers of the court, the officers coming from the IG today, for that reason alone that they are officers of the court, they ought to know that court orders must be complied with. My Lord, we are all officers of the court. When we don't respect the court, we cease to have the right of audience that we have before this court. We get that privilege because we respect the authority of the court. The court has given significant importance that the citizens of this country because of the rights guaranteed under the Constitution, declared and not given as of gift by the state, will not be denied without a proper legal framework and explanation to this court. That is how important this sitting is. Let us not make it a forum to bicker between the two sides of the bar, the Attorney General or the DPP and the side of our side of the bar on why and who should have audience. No, we are talking about lives of citizens of this country. This court has issued specific orders and has convened to confirm whether its own orders have been complied with. This court can confirm that without these antiques by the other side of the bar. My Lord, people cannot just disappear. We are run.
Opinion for someone to follow or not. They are a direction that have been given after so much thought, my Lord. On the matter of contempt, the first respondent was given an opportune time to respond to it and to appear in court in order to purge that same order. The first respondent has declined or has blatantly declined to show up in court, my Lord. Not because there are more important things than a court order, but because of a choice, my Lord. It is his obligation, and when taking oath of office, he stated that he will uphold the Constitution and the rule of law. It is quite shocking that the officer who is supposed to uphold the rule of law is the one defying orders. We are therefore praying that he be held in contempt, because as the ruling stated, your ruling, my Lord, stated, that the court has teeth and it can bite. It is at high time that it beat and it beat hard. That's all, my Lord.
So, is on the validation forum for the final review of work plan and budget. As the head of security, which is key to this mission, and his work constitutional duty, he had to attend the same function.
Kindly, Your Lordship, may I offer my objection to the same. My name is Moniki. Counsel is testifying rather than submitting on the law for the petitioners. Your Lordship, we do contend that if counsel continues to adduce facts, we should be treated or allowed to cross on the same.
My Lord, the reason why I came with an officer from the office of the Inspector General is for him to adduce this document and produce them before this court. And the Inspector General has not said that he's not coming before this court. What he's asking that he should be given another date. My Lord, the petitioners went way deep into the substance of the petition.
First and foremost, we have not accepted your independent right because there is an issue of content that is pending, which we must deal with. That is the procedure. Once there is content, you cannot look at any other matter until and unless either you punish for that content or you purge the content. So that is what we are dealing with.
Yes, my Lord,
we will go to those other issues that we are raising, whether or not they are in custody of the police, whether or not they were arrested. So still, we still have your time. We will still come. We will deal with that at an appropriate time. Yes. But for now, the reason why we convene this sitting is because of what had transpired before. And that's what we are trying to deal with.
Yes, my Lord, then we'll be requesting.
We had given you all the opportunity from 23rd to bring up those facts with regard to the issue of these petitioners. Second to fourth petitioners who are still abducted and their whereabouts are unknown.
My lord,
Then,
this petition,
when-
actually we can go into the substance of
Can we have
The
the court?
issues of
Can we
data.
have the court address us without having an exchange with the court?
Miss Mongi, we can't do that because, you see, for us to move forward, we must deal with the issue that is before us, and that is the attendance of the Inspector General of Police to explain why the orders which the court has issued to date have not been complied with. Simple.
yes,
And I expected you to tell me, I have the Inspector General of Police here, he is supposed to explain ABCD, and then we move forward. Simple. It's that simple. It's not complicated. So we cannot keep on going round the same issue. We need to come direct. Tell me you don't have Inspector General of Police. As a court, you are free to do what you want, and I will do it. Yes.
he's aware of the court orders and is willing to obey the court orders and is seeking for the court's indulgence today. My lord, that is what I was trying to explain. He sent his officer here. I thought the officer would explain better than me. We're requesting that the court indulges the IG and gives him another opportunity to appear before this court. Considering his nature of work, his nature of duty, he's in charge of the security of this country, which is a very critical duty to this country.
A cynical disregard of the authority of this court and the principle of the rule of law. You are being told, my lord, that the respondents chose to edit your order and have decided for themselves when they can obey the order, my lord. That, my lord, a workshop is more important than the lives of 3 citizens of this country. That the right to life and the right to liberty can be suspended because of a workshop. A workshop that the IG can delegate to the deputy inspector generals. And you remember, my lord, on the 3rd when we were here before you, you were informed that the IG was out of town. But immediately when we left this court, the cabinet secretary in charge of interior published photos online on his official Twitter account meeting this same person who cannot obey court orders. The court can take judicial notice of that.
Evidence from the bar. They have been calling me out for giving evidence from the bar. I believe that is also evidence from the bar. And you object submissions on that line, my lord.
Mr. President, you can confirm yourself to what we have today so that you focus.
Yes, my lord. What you are submitting is that this court cannot be left to babysit its own court orders. Once orders have been issued, they must be complied with unless they have been set aside. My lord, we submit that the lives of Kenyans and the place where their families have been put into cannot wait until when the IG chooses when he can come to court. We submit that Monday is too far, my lord. A flight from Mombasa to Nairobi is a maximum of 45 minutes. And for him who has security guards, they can even take less than that. submit, my Lord, that they should come to court and they should obey these court orders that have already been issued, my Lord. That's all from us.
Missing.
That is.
My Lord, I introduced myself that I'm coming on behalf of Bob Njagi.
Your name?
My name is Omar.
Mr.
Omar.
Mr. Ward.
My Lord, as I said in my earlier submission to you, the counsel representing the IG is missing the point. In dragging this court to a side issue which is not relevant for today's sitting. Persons who are citizens of this country have been missing for the last 3 weeks. This court, in its ruling on the 3rd, had very specific pronouncements. Before it came to the conclusion and the order that the IG must explain himself. One, to explain if and why these people are arrested, abducted, and remain in custody. Two, in the event they have any other explanation, they ought to appear before this court by virtue of their constitutional responsibility to accord every person security in this country. It cannot fall in their mouth to choose how to explain it, to vary the court order, and choose how they want to comply with it. Today we are told the IG is at Mombasa doing a workshop. The sitting of this court was to be at 10. The IG is someone we take around this country in choppers. You could have attended this court and still be in Mombasa today. My Lord, this court has given orders to ministers before. In our last sitting on 3rd, we quoted for you the case of the Constitutional Petition 51 of 2018, Miguna versus Fred Matiang'i, and we restate that this court has the power to summon the IG or any person. And when that summons are given, those summons must be respected. We have families who are brothers to petitioners, siblings to the petitioners, parents to the petitioners, who don't know where the persons they are interested or they care about are missing for 3 weeks. Either this constitution protects its citizens or it doesn't. Either this constitution is where the IG derives this power, or the IG can assume some powers that this constitution has not given, and which are beyond the purview of this court. My Lord, we invite you to reject any explanation by the IG, to sit on the specific issue of today's sitting and to find and punish for the contempt.
I've suggested that it has come from them. I humbly submit that it's just 2-3 days away. Give them their last chance. It's because they have suggested a specific day and they have consulted an officer from that institution here. I humbly request the court to consider. given the seriousness of this matter. Thanks.
Like she has said on Monday, so that we can move this matter forward. So, in a nutshell, I would have no objection to the AG's request. And I request the court to consider the same. That would be all.
Of September 2024. This is a matter of great concern affecting the liberty or the life of Kenyan citizens. The court noted that for almost 2 weeks, these persons who were allegedly abducted are nowhere to be seen. Their whereabouts are unknown. The IG has the ultimate responsibility or authority to protect every Kenyan. It is perturbing that the claim of abduction is associated with the police officers under the command of the IG, yet to date no response has been made to that effect. I am informed that the IG has now filed a replying affidavit, but with the content of court proceedings ahead of that filing, this court is precluded from looking at at the contents until the issue of disobedience of the orders is first explained by the person to whom the order was directed. As for the adjournment of this matter to Monday, the 12th of September 2024, suggested by the AG, the court finds the requests impossible to implement, considering that the IG was fully aware of the order at the point of attending the workshop. And as clearly expressed by one of the petitioner's advocates, this session is happening this morning, and the court does not see why the AG did not prioritize the court order over the workshop, noting that the court order is not optional and the AG has to obey the same. I leave it to the IG to consider if he is to obey the court order today and present himself by 3 p.m. If the court does not see the IG at 3 p.m. or 3 o'clock, shall thus convene at 3 p.m.
We are most obliged.
Thank you.